call the Sherwood City Council regular meeting for July 19th, 2022 to order. Gavel action there. If you're wondering where Keith is actually joining us, Mayor Mays, via Zoom today, and he asked me to run the meeting today since he'll be on the Zoom call. So that's why you get to deal with me tonight. So first of all, I'd like everyone to stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you, everyone. And Sylvia, roll call.
Mayor Mays.
Here.
Council President Rosner.
Here.
Councilor Garland.
Here.
Councilor Young. Here. Councilor Stott.
Here.
Councilor Giles.
Here.
Councilor Rouse is absent.
Thank you, Sylvia. And approval of the agenda. Do I have a motion?
Make a motion to approve the agenda.
Second. Motion and a second. Thank you, Kim. Thank you, Taylor. Any discussion on the motion? Didn't think so. So all in favor of approving the agenda, say aye.
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 Opposed? And motion passes. Thank you. Next is we're moving on to our consent agenda. We have A through H tonight. And just a note to the public on this, there was a minor update on C, Resolution 2022-055. We added a name to that, Daniel Vance, prior to the initial packet that went out, had TBD in that. And then we also added Resolution H, which is 2022-060, is new tonight. And we just added that in the last. It's actually on the website. We have copies in the room if anyone would like to see exactly what that is. So on the consent agenda, again, we have multiple items here. We have A, approval of the June 19th, 2022 City Council meeting minutes. B, Resolution 2022-054, appointing Alan, I know I'm going to get this wrong, Raplia as interim city attorney. Resolution C, 2022-055, forming and appointing the members of a technical advisory committee to update the 2021 economic opportunities analysis. And as I noted earlier, that's where we added the name. Item D, Resolution 2022-056, authorizing the city manager to sign a service order with 1547 CSR Pittock Block LLC for data center space and connectivity. Item E, Resolution 2022-057, authorizing the city manager to enter into the Washington County Emergency Management Cooperative Intergovernmental Agreement. Item F, Resolution 2022-058, authorizing the city manager to sign a professional services contract with KPFF Consulting Engineers for 100% design level of the Highway 99 pedestrian overcrossing project. Item G, Resolution 2022-059, reappointing Casey Chin to the Cultural Arts Committee or Commission. And last but not least, item H, Resolution 2022-060, authorizing the city manager to acquire real property. And that's the item that, as I noted before, we added.
I move consent.
Second.
That was a race. Thank you, Kim, and thank you, Mayor Mays. Discussion on the motion? No. All in favor, say aye.
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 Opposed? Motion passes. Thank you, council. So now we will move on to citizen comments. I apologize. I was just making sure this doesn't have anything to do with our hearing later on tonight. All right, RJ Kloss. Thank you for coming tonight. Just go ahead and state your name and your address and let us know what you want to talk about.
A little bit harder for green.
Push and hold.
There you go.
There you go.
Thank you. This is part of an effort to exhaust administrative rights, reach finality, because it now looks like there is little or no chance we'll stay out of litigation with this city. Now, it is amazing to me the things that come down. For instance, one of your planners made the preposterous statement that the fees to appeal were to cover their costs. That's not true. We were on the committees when Walt Hitchcock was mayor, and Walt Hitchcock is the one that introduced that, and he introduced it specifically to discourage appeals. And he said so, made no bones. But he was not a Keith Mays, although he unfortunately brought Mays into the town. And you could talk as long as you did not repeat yourself. So all of us, including Lou Fasano, who was ready to litigate over it, God rest his soul, decided to leave that in place. Your planners are here and they are not lawyers, but continually they act like it. Now, in only one state did APA, the American Planning Association, ever get their people registered and required to be certified to work in the state, and that lasted just long enough for the lawyers to slam the governor around a few times. And sure, these people are not professionals, they're not lawyers, and they should not be practicing the law. And that's what's happening here. Every time you don't look at a code, your planners start interpreting it. Now, Joyce Sober, as much as I like Joyce, can't do anything about it because he really works for the city council. He now works for Barry Elsner, and God help him. It's just turning into a zoo. You don't have an attorney that you can talk to about what you're doing. So you're forcing litigation. And that's a bad road to go down with me, because I will not litigate over money. I will litigate over principle. If you don't believe me, ask Bill Cohen of the US Justice Department. When he was forced to settle an 8-year suit with us, he said, "You want what you wanted day one, and that's all. Are you an idiot? We've almost bankrupted you." I said, "I didn't litigate this for money." And when this litigation starts, you're in the same boat. You're picking on elderly people. Mays is clearly taking zoning away from us, and in spite of what your charter says, he is continually passing zoning on to contributors of his. It's a made-to-order lawsuit for what's wrong. When I taught planning, and I've taught it in university level, particularly Canada, I taught them, if you can't determine as a planner what the word means, don't play lawyer, go get a lawyer. What happens here? Your planners interpret it. We've been told, in spite of documents that say, oh, it's over with in 2 years. That's not what the documents say. And it's not an attorney saying that. Now, if I were you, I would spend some really serious time thinking about it, because some of this is going to get quite ugly. It did with a former mayor, and he is not politics anymore. And there was one other that left. There's no reason for this. This is a small town, and there is no reason you should provoke a citizen into filing a lawsuit, particularly when they're elderly, ill, and are going to ask for triple damages and attorney's fees.
Thank you, Jim. Sylvia, was that it? Do we have any other? That's it. Okay, great. All right, so we're going to move on to a public hearing tonight. And Josh, I believe you're going to set us straight on the process here.
Yes, and please bear with me. It's quite a long statement that I have to read for you. Tonight, the City Council will hold a public hearing on a land use appeal from the Planning Commission. The City Council's role is to review the record of the proceeding before the Planning Commission and the appeal documents, and conduct a public hearing considering solely the evidence already in the record. In making this decision, Council must apply the applicable codes and laws and cannot vary from or change those laws or codes. A staff report has been prepared for this appeal and was made available to the public 7 days before today. Staff report identifies the approval criteria that apply to this appeal. Staff has analyzed the appeal issues, relying on the reasoning set forth in the Planning Commission's decision. The quasi-judicial hearing procedure that council will follow is set out in state law and the Sherwood Municipal Code. The hearing procedure steps we will follow tonight will be: first, staff will present the staff report, which will be approximately 15 minutes. Second, questions, if any, by the hearing body for staff. Third, we will then open the public hearing for testimony, and time will be limited as follows. The appellant will have 30 minutes split between presentation and rebuttal. The applicant will have 30 minutes split between presentation and rebuttal. Persons who testified during the proceeding before the Planning Commission will have 4 minutes each. And in this case, there were not any other than the applicant and appellant. So we'll skip that step. Rebuttal from the appellant for the remainder of their 30 minutes, and rebuttal from the applicant for the remainder of their 30 minutes. Then fourth, final comments by staff, which will be approximately 15 minutes. Fifth, questions of staff, if any, by the council. And then finally, sixth, deliberation by the council. As noted, a hearing for this type of matter is limited in 2 ways. First, only those individuals who participated orally or in writing before the Planning Commission may be heard. And second, the only evidence that council may consider is the evidence that was presented to the Planning Commission. No new evidence is allowed. Anyone wishing to speak as part of this hearing should have either emailed the city in advance of this hearing, as described in the notice of the hearing, or have filled out a speaker request form located at the back of the room and turned it into city staff. For the public record, please begin all testimony by stating your name and address. Testimony and references to evidence should be directed toward the applicable approval criteria and limited to the issues raised in the notice of appeal. If you believe other criteria apply in addition to those addressed in the staff report, you should identify and discuss those criteria and explain how and why you believe they apply to the appeal under consideration. Any person may submit written material while the public record is open, so long as it does not contain any new evidence. Any written materials received by city staff during the time period in which the record is open will be placed into the record. Written materials submitted during the public hearing must be presented to city staff in order to become part of the record. If the city council makes a decision with which you disagree, any issue that you may wish to appeal must have been raised before the Planning Commission. If the issue was not raised on the record with sufficient detail and accompanied by statements or evidence that the city and all parties could respond to, the issue will not be deemed appealable to the State Land Use Board of Appeals. In addition, the failure of an applicant to raise constitutional or other issues related to proposed conditions of approval with sufficient detail to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Members of the City Council participating in this hearing must be unbiased. If a member of the City Council has a conflict of interest, such as family, financial, or business relationships with any of the applicants, or with regard to the property or proposal in question, they must disclose that conflict of interest. And if it is an actual conflict of interest as opposed to a potential conflict of interest, generally must not participate in the hearing. Members of the City Council who have received ex parte contacts related to this application, such as discussions with any person outside of this hearing, must disclose the substance of the contact. In addition, if any counselors have independent knowledge of relevant facts, such as from a visit to the site in question, that must also be disclosed. This review is limited to the record, so any facts resulting from an independent site visit or otherwise outside of the record may not be considered as part of this appeal. Do any members of the City Council need to disclose any bias, conflicts of interest, or ex parte contacts?
I was just gonna inform you that I heard this as the City Council liaison in front of the Planning Commission, but I did not participate in the deliberations, and I plan on participating tonight.
Anybody else have anything that they need to disclose?
Conflicts?
I do rent a storage unit at Sentinel Storage, but I do not believe that will have any impact on my decision tonight.
Like Mayor Mace is raising his hand.
Mayor Mays? Mayor Mays, you're on mute.
Apologize. Thank you. I also rent a unit or 2 units, but not at the location of this project. It's another location. I have not talked with the applicant or the property management company about this proposal. I have met one of an attorney that works for the applicant, but we haven't talked about, I never talked about what he does. So I don't even know if he's a party to this application. Josh, as a customer of a different area of Sentinel Storage, do you interpret that as a actual or potential conflict? And should I participate, in your opinion?
That sounds to me like it would at most be a potential conflict of interest. I don't see how you would economically be benefited or harmed by the result of this particular decision. So it does not sound like a necessitates for a recusal in this case.
Thank you. Thank you, Josh.
I'll just add to my disclosure, I too rent, but also in a different location, so I didn't consider that as part of my.
Okay. Does anyone in attendance wish to challenge or question any of the counselors about these disclosures? Okay. Can you go ahead and step up to the microphone so we can record it, please.
I challenge you absolutely to have any right on here. You're both biased against me, and I don't like you any more than you like me. And number two, you have a direct conflict of interest. You have continually taken things like the urban renewal project and misdirected the money where you told it was going and put it into Langer's on Langer's Farm Way and transformed that whole property. And you sat in the room when Clarence Langer and Brennecke had taken that piece from Orspada and they had fooled it from light industrial into Home Depot's retail commercial, and you did nothing about it. You have done nothing but benefit that group, and you have absolutely prejudiced against anything I say. And of all of the people that should recuse themselves in the interest of the city, it's yourself, because you have financial interests, which we will pursue with ethics if you stay on this tonight, and we will pursue your constant badgering me through your staff members. You have 2 staff members that have targeted us and been willing to break both constitutional law in the state of Oregon and case law and proceed to tell buyers not to look at our property because you don't like us. And I'm going to tell you, you don't belong up there anytime anything comes up with your prejudices. And you should just recuse yourself and give the city a little breathing space.
I do believe back in the day, the city did challenge the Home Depot thing. The county gave us money to build most of Langer Farms Parkway, some of the other points. If council would like me to recuse, I have no problem recusing. 0 issues one way or the other. What is the will of the group? I trust y'all.
Mayor Mays, I think the operative question is whether you have any bias that would render you incapable of rendering a decision based on the criteria in this case.
No.
And I don't feel that you do.
But if it, I don't know, part of me just says the heck with it. I'll let the 5 of you deal with it. Because majority of what was said by Mr. Claus is a pretty good book of fiction.
I think to Josh's point, the operative question is whether you think you have bias or not. And I think you clearly said you don't. So I'm fine with you participating.
Yeah, I was gonna say, I don't think you do either. Will it make tonight's procedure go better regardless of whether there's any fact in what was just said? I mean, we've got 5, so we have a quorum.
That makes my night easier. I'm under the weather. So why don't I just step back just out of personal.
I don't, yeah, I mean, several of us are customers of the, like, I don't know that what the legality is of this. And so I'm looking squarely at you. I mean, he says he's not.
Oh, there's zero
biased.
claims, there's zero nothing.
Right, so bias is a pretty high bar to prove. It doesn't sound like Mayor Mays has a bias.
Yeah.
It's one more argument for a to be possibly raised on appeal, but it seems like
With the
I
25
think
years
it's
of
really
doing
up to
stuff
the
for fun, I'll just recuse myself and let you guys tackle it. I have full faith in the five of you hearing this in a fair and impartial way and ruling accordingly. So why don't I
Well, we can honor that request, Mayor, but I just want you to be clear, at least from my perspective. I appreciate your willingness to make sure that there's no potential issues down the road, but I clearly don't believe you have bias. So
it is a book of fiction, but
awesome. Okay, so we'll move forward without the mayor. And
that concludes my statement, and we will now commence with the staff report.
great. So step one, I wrote it all down. Just make sure I got all this, Josh. So step one, we'll do our staff report. So welcome.
Good evening, Council President Rosener, Mayor Mays, and City Council. Happy to be with you. Eric Rutledge, Associate Planner here at the City of Sherwood. Happy to be giving the presentation for LU 2022-004 Sentinel Storage. This is a major modification land use appeal hearing. And we also, of course, have Josh Soper as staff who was helping on the appeal and can answer any questions for you after the presentation. So I'm going to go over briefly the site and the application proposal, and then go over the issues that have been raised on the appeal. So the applicant is Langer Storage 2 LLC. The appellant is Jim and Susan Claus. The proposal is for removal of an existing RV canopy and replacement with a 3-story self-storage building containing approximately 575 storage units. The zoning on the site is light industrial PUD, and the procedures are a type 4 land use action. Planning Commission made the initial decision, and that was appealed to you. City Council is the final local decision maker on this land use application. We did receive one additional piece of testimony after release of the staff report. You should have that in front of you. We labeled it Exhibit A. It's from Jeffrey Kleinman, who's representing the appellant in this case. So hopefully you all have that. It was forwarded to you via email as well. The applicable criteria of the Sherwood Development Code is shown on this slide for reference. This is what the Sherwood Planning Commission issued their decision on. So get into the site and existing conditions. So this is located at 21900 Southwest Langer Farms Parkway. It's a 6.14 acre site. The site is fully developed with an RV storage and self-storage buildings. This includes drive aisles, utilities, and landscaping. So here's the site here. It sounds like most everyone's familiar with it. This canopy, it's kind of hard to tell, but it's a canopy here in the middle of the site is what is proposed to be removed and then replaced with a 3-story self-storage building. So this site was approved in 2016 under a site plan approval. And now the applicant is proposing a major modification to that site plan approval to replace this canopy structure with a 3-story building. In terms of public facilities, there's public utilities in Langer Farms Parkway, and there's also Langer Farms Parkway, which is a 3-lane collector status road that's fully built out. Access to the site is from this private driveway on the south end of the site. The zoning and surrounding land uses, the zoning is light industrial PUD. Surrounding land uses, the Langer Entertainment Center to the north, additional storage to the east. This is a multi-tenant industrial building to the south, and then the St. Francis School and Church and some residential property to the west. The property is within the Sherwood Village PUD. This is a PUD approved by the City Council in 1995. So the PUD is shown In the gray outlined here, the subject site is within phase 8. So phase 8 outlined here in red. So over the years, there have been various modifications to the PUD. Most of it has been built out. It includes the Walmart, the Target, some residential townhomes here, and then this light industrial zoning towards the south. So the way that all PUDs are set up in the city is the applicant gets the initial PUD approval that happened in 1995. They state the phases that will occur and the uses and the zoning for each of those phases. And so again, this was phase 8 with the zoning of light industrial. And so the proposal in front of you this evening is not a modification to the PUD. It is a modification to the site plan approval for this specific site that was approved in 2016. Here's the site plan and site layout. So Langer Farms Parkway here to the south. This would be facing east, so be on Langer Farms looking into the site from the road. So the gray are all the existing buildings, and then the black outline here is where the canopy structure would be removed and replaced with a 3-story building. The orange color here is the first level loading, and then landscaping shown in green around the site. And then in terms of the building design, since this is on a collector road, Langer Farms Parkway, it is subject to the city's industrial design standards. Here's the 2 elevations or 3 elevations that will be viewed somewhat visible from the roadway. So in order to meet the industrial design standards, the applicant's required to use 2 different building materials, which they're proposing, have a maximum setback of 35 feet from the road, which they comply with, and then have parking, loading, and mechanical equipment not visible from the street. Most of it will be shielded or screened from the existing buildings that are there. So it is subject to industrial design standards, and the staff report was that it complied with those. And now getting into the issues on the appeal. So the appeal was really focused around the use determination that self-storage continues to be a permitted use on the site. And then there was one other issue that was raised on appeal. Both of them are related to ORS, so Oregon Revised Statute, state law, as it sort of trickles down into the city code and how we implement city code as it relates to the state law. So the first appeal issue. The appellant argues that the Planning Commission misinterpreted ORS 92040 as it applies to the application and the factual history of the property. ORS 92040 does not allow the applicant to ignore the provisions of the Sherwood Development Code to cite a use that is expressly prohibited by the code on the subject property. So that's the appellant argument. The Planning Commission found that self-storage is not a permitted use under the current light industrial zone. So they agreed with the appellant on that. However, the use is permitted on the property until August 28th, 2022, pursuant to ORS 92040 and the previous land use approvals issued for the property. So to get into the detail on that, what ORS 92040 states is, and these bolds are things that I have added for emphasis, they're not originally bolded, but the ORS states, after September 9, 1995, when the local government makes a decision on a land use application for a subdivision inside an urban growth boundary, only those local government laws implemented under an acknowledged comprehensive plan in effect at the time of the application shall govern subsequent construction on the property unless the applicant elects otherwise. So that's the second bullet point of the ORS. And then the third says, a local government may establish a time period during which decisions on land use applications under subsection 2 of this section apply. However, in no event shall the time period exceed 10 years, whether or not a time period is established by the local government. So that's what the ORS says, very wordy, but how it sort of relates to the application and the use determination by Planning Commission. So in 2012, there was a subdivision that included this property that you're considering this evening, also other properties all on the east side of Langer Farms Parkway. That subdivision was approved in 2012 on August 28th, 2012. And when that subdivision was approved, the zoning on the property was light industrial. And the light industrial code at that time said, approved PUDs may elect to establish uses which are permitted or conditionally permitted under the base zone text applicable at the time of final approval of the PUD. So what this is saying is that if you're electing a use under the, or if the zoning is light industrial under this 2012 code, you can either utilize the uses that were permitted when the PUD was originally approved, and that would go back to 1995. So this 2000, when the subdivision, going back to the subdivision, when it was approved in 2012, that code said, if the zoning is PUD, which it was, you can go back to the code or to the uses in effect when that PUD was approved. So that was 1995. So that's the first part of it. The second part of what the 1995 code actually said was if the zoning is light industrial, the permitted uses in the light industrial zone include uses permitted outright in the general commercial zone. And so going back to the 95 code, if your zoning was light industrial, you could also take advantage of any of the permitted uses in the general commercial zone, and that included mini warehousing. So that's how we get to the specific use of mini warehousing. So you could work this backwards as well and say in 1995, the zoning on the site was light industrial that allowed uses permitted outright in the general commercial zone, which includes mini warehousing. So warehousing was a permitted use in the light industrial zone in 1995 when the PUD was approved. When the subdivision occurred in 2012, the code in effect at that time said that if you have an approved PUD, you can go back to the uses that were in effect at the time that the PUD was approved. And then how we get to today is under this ORS, going back to this, that says only those local government laws in effect at the time of application shall govern subsequent construction on the property unless the applicant elects otherwise. That's how we get to today. And again, that this period, in no event shall the time period exceed 10 years, whether or not whether or not a time period is established by the local government. So that time period, we, in staff's opinion, have not established another time period other than the 10 years. And so the subdivision was approved on August 28th, 2012. And so the staff, really the planning commission finding was that the self-storage use is permitted on the property until August 28th, 2022. So that's how we get to the use. That's what the commission found. So that was the appeal issue 1, and happy to answer questions on that after the presentation. The appeal issue number 2 was related to the open record period under ORS 1977976B. Go back one more. The appellant is arguing that the planning commission made an error by refusing to keep the record open at the continuance hearing as demanded by the appellants pursuant to RS 197. The applicant and staff offered new evidence which appellants were not given the opportunity to rebut. And so just a little background on the timeline here. So we had the initial evidentiary hearing. The appellants provided testimony at that hearing and requested that that hearing record be left open. So we did that, came back 2 weeks later. At the continuance hearing 2 weeks later, the appellants again requested that the record be left open because new testimony was submitted, or I'm sorry, new evidence was submitted at that continued hearing. And what the planning commission said was what was submitted or not at that, basically no new evidence was submitted at that continued hearing, and therefore the record was not required to be left open for additional time. So I think that's what I just said here, the planning commission found. So the details on that is that the state law that was quoted says an opportunity shall be provided at the continued hearing for persons to present and rebut new evidence, arguments, or testimony. If new written evidence is submitted at the continued hearing, any person may request prior prior to the conclusion of the hearing, that the record be left open for at least 7 days. So I bolded this for emphasis, if new written evidence is submitted at the continued hearing. I'll get to that in just a second, but then in sort of the definitions section of this ORS, it clarifies what is an argument and what is evidence. And so the commission would have only been required to leave the record open if new written evidence was submitted at the continued hearing. So definition of evidence, it means facts, documents, data, or other information offered to demonstrate compliance or non-compliance with the standards believed to be relevant to the decision. So a few different points on why the commission did not think that there was new evidence. First, at the continued hearing, staff gave a staff presentation. No new evidence was provided in the staff presentation. We believe what the appellants are referring to is a letter from the applicant's legal counsel. And this letter was in response to all of the testimony that was received at the initial hearing and, just through the record. And so that we can pull it up and go over it if you'd like, but that's in the record. So the first is that either through staff or through this letter, no new evidence per this definition was actually provided at the continued hearing. Second is that the state law is pretty clear. It says new written evidence is submitted at the continued hearing. The letter that was submitted from the applicant's legal counsel was provided via email to staff prior, uploaded to the website. Documents or copies were provided here, but it was actually submitted prior to the hearing and posted to the city website. And then finally, just to, I think, reiterate this point about the no new evidence, if we go back and read even the title of that letter that we believe they are referring to, it very clearly on the top of that letter, the title says rebuttal to testimony submitted by the clauses. And so as varies, here's the point raised. Here is the sort of legal response to that. It was nothing sort of, brand new. It was strictly a response to what was already in the record. And so for that reason, the commission found that the record did not need to be left open for additional time, and they closed the record and issued a decision. And so the appellant is appealing on that procedural issue as well. And with that, the staff recommendation is for city council to affirm the planning commission decision and approve the application. You do have alternatives this evening, and we'll help you get to whatever outcome you feel is best. You can affirm the planning commission decision. You can affirm the planning commission decision with amendments, or you can reverse the planning commission decision and deny the application with revised findings. And the same sort of approach that we went through with the previous appeal. This is all tentative decision. With the included in the motion would be the authorizing the mayor to sign the notice of decision, including written findings consistent with the council's tentative decision on or before the 120-day deadline of August 4th, 2022. So you tell us the decision, we'll draft it and have the mayor sign it. And that concludes the staff presentation. Happy to answer any questions.
Thank you very much, Eric. That was super helpful. So thank you. Just a real quick question. For Josh, since the mayor recused himself from this, I'm assuming I would be the one signing that, not the mayor, depending what the decision is tonight.
I think that would be appropriate, yes, to change the motion to have the council president sign.
Yep. Okay. So we'll have to remember to do that. Yes, at the end. Okay, great. Any questions from council?
I had one. So when was the rebuttal letter received that you just referred to? Was that, we had the meeting, and then I assume it was continued for 2 weeks. When in that 2 weeks was that letter received and published?
Yeah, just a few hours before the continued hearing.
So we got it as a city a few hours before the continued hearing, but not during the hearing.
Correct.
That's what you're saying. It was, okay, thank you.
And I think, just to go back, I think the most important point of that was that what was included in that letter was not, in our mind, new evidence.
Right. Yeah, no, you made that clear.
Say our mind, that was the conclusion of the planning
Planning
commission.
Commission.
Yes, thank you.
Yeah.
I have a question about the 10 years. So if I'm hearing this correctly, when the original site plan was approved in 2012, there was no time period established at that point in time that said, and that am I correct in saying this? And the 10 years is just being assumed as applicable by default?
Yeah, so if we go back to the ORS, the way that the commission interpreted the ORS or applied the ORS is that the applicant had not, when the 2012 subdivision occurred, the applicant had not elected a different time period other than the 10 years. The appellants and
Can you go back to the language of the?
Yep, sorry, one more, there you go. So this number 3 is, in no event shall the time period exceed 10 years, whether or not a time period is established by the local government. So the way that the commission interpreted and applied this subsection 3 is that at the time of the 2012 subdivision, the applicant had not elected a different time. The appellants, I don't know if it's really on the appeal or not. It wasn't all that detailed. But in the original testimony that they provided, they did contest that they basically said that the private development agreements the development agreements that the applicant entered in with the city actually established a different time period. Those expired in 15 and 17 off the top of my head. And so the appellant's argument, at least in the original testimony they submitted, was that those development agreements established a different time period other than the 10 years. The commission finding on that was that those development agreements were signed and executed before the 2012 subdivision. And so it just isn't really all that logical to say, and there's nothing in the development agreements that talks about ORS or subdivisions or
Sure.
Anything like that. It just says here's a development agreement. And so because those agreements occurred before the subdivision, it's just not really, doesn't make sense.
Putting that aside, I'm still trying to figure out how you get from this code to saying, well, everybody gets 10 years, even if nobody says anything. Because I read this to say not to exceed 10 years, but I don't see anything about a default 10 years. So maybe we'll get to that as we go through the course of this, but.
I suspect that the appellant's legal counsel will speak to that. I assume they'll pick up on that point and speak to it.
And I can briefly address that too, that if you read that whole section 3,
Yeah.
it's saying that the local government has the option of establishing a time period.
Right.
But then it says the period will not exceed 10 years, regardless of whether the local government establishes a time period.
So but it doesn't say you get 10 years and we don't say anything.
I'll agree that it's not written as clearly as it ideally could be. But I think that it read in context with the section, there has to be a time period. And there's no other time period that's set.
Yeah,
So-
presumably there has to be a default time period, but
Right.
this doesn't seem to be setting one in the way I read it, but I understand what you're saying.
But missing that information, the only thing we have to assume is the 10 years. So if we didn't set a 5-year, if we didn't set a 6-year, do they get 2 years or do they get 10? As long as there's not more. Yeah, I think there's some missing information in the ORS that the state could probably be a little bit more clear, but absent that information, the only thing we have to go by is 10 years.
Thank
Do we have more question back to the staff later after? Do we have another question
You
period?
can, but if you have questions now would be a great time to ask them so that the applicants and appellants have an opportunity to
gotcha.
respond to those questions as
Okay.
well.
I don't have any more at this point. That's
So from a procedural point of view, Josh, you were assisting staff throughout this to make sure we're correct legal interpretations as far as staff is concerned. And I'm assuming you have outside resources that you use to as part of that process.
Can I amend that as well? Were you also assisting the planning commission in their
That's correct as
meeting?
well, yes.
Well, perfect. Okay.
Am I wrong in assuming that self-storage is not an allowed use now on this?
Under the
Under the
current, under
current code.
today's code.
Okay, so that's why there has,
self-storage
that's why
is
this is the
not.
issue. Okay.
Otherwise, yeah, correct.
Seems like the contents of this letter might be an issue. So, I mean, or might be at issue, not an issue. So maybe we should take a look at it, but that's one voice, so.
Sorry, contents of which letter? The
The
rebuttal letter?
letter that was saying that, I think the appellant is saying this letter might have contained new,
No, he's
Oh,
saying,
the
he's saying the rebuttal letter. Yeah.
yeah, but that letter might contain new, I think evidence is the word, that then would compel the planning commission to grant a continuance. You're saying it doesn't. I don't know. I haven't seen it, so.
That's what the commission found. We can reference the letter. It's in the record. We can pull it up for you.
Would it be of value to have him do that before? I mean, should we see
I
that
mean,
letter?
I'm more than happy to look at the letter. I don't know if I'm qualified to say if information in it was presented before or after. I mean, that's what we rely on our planning commission for, and and they were in front of all of that. We
Yeah.
haven't been in front of all that, so.
I can also see a conundrum forming, right? If somebody sends a letter to rebut something somebody else said under testimony, and then someone replies to that letter with another letter, then it just becomes this never-ending cycle of letters. If all of that is deemed evidence, then you could in theory never close a hearing.
Exactly, and that's
So you
what
could
would
run
happen.
out of time, yeah.
Mhm.
And would that cut, if theoretically that would cause us to run out of time on the 10 years?
Or on even the
The
1
hundred
year.
and 20 days. Yeah, the
Yeah,
120 days that we're
120
under
days,
is the big gun that we're under. Yeah, and yes, and that's why the definition really is important to say, all right, with whatever was submitted last, is this where we can say, that's it? You know, that this wasn't evidence, and so then
Yeah.
we're done.
It's interesting though, if somebody raises evidence and then somebody else replies to that. I mean, you could see a case where the reply could contain new evidence. But you could also see, but at what point does it go from, I'm just addressing the points that were previously raised to actually bringing in new evidence? I don't know what that threshold crossing is, but that seems to be an issue here.
Right, and that's where the definitions of argument versus evidence come into play. And then, of course, also to your point, Counselor Scott, it's not a never-ending cycle, because at some point you don't continue the hearing, you just leave the record open, and there's a for written responses, and there's a finite number of days that process happens.
Without seeing the letter, it seems to me if an attorney is responding to argument or arguments made, they're arguing back to the arguments.
I do think it is important that we make sure that the counselors have an opportunity to review that letter so they can make their own judgments. So if we can just
Yeah.
point them to where that is in the record and give them a few minutes to do that, that would be great.
Is it already in our packet?
Yeah, it's gonna be
Give me a
in,
page. I
In
have
these
1,452
5,000 pages?
pages.
so I'll give you a little bit to start with, and that's Exhibit D18. And then let me go grab
Okay.
the full binder one second.
On page.
Bring you the binder.
I can make copies for you while the other presentations are going on. Yep. Yeah. Perfect. Yeah, I can answer other questions while Josh makes the copy, or we can turn it over to the.
That's great.
applicant.
I can't see if
Oh, Sean,
Sean,
or
did you have any questions?
Sorry, I do not. I'm just scrolling, trying to find that letter as well. So if somebody can
oh, we still
identify
need to
a
find the page for
page
Sean, yeah.
number, yeah.
Yeah, we'll get you a page number as well.
Thank you.
For 1 sec, yeah.
And Sean, I can't see if you're raising your hand, so feel free to just jump in if you have a question.
I will be assertive. Thank you.
Awesome.
there on D10.
And what page was that on?
I'm at 786 right now.
Josh is going to make us copies, so
Oh, that's
he's
right.
gonna bring them back while we move on.
All right. Okay, so we will move on. Thank you very much, Eric. And yeah, I actually, let's just pause until we get Josh back in the room.
Yeah,
I think that's important.
just take a 3-minute recess or pause. Okay.
I turn this off.
We need a packet page number. That would be helpful. Sean, it's the very last exhibit in the packet is what I'm being told for you.
Excellent. I will look for it there. Thank you.
We're not talking right now. Hey, Jim.
While we sort that out, here, it's some of that. It's actually 16. Sorry. Oh, it's not stapled, so.
Sean, it's actually exhibit D16.
Sean is page 1417 in the packet.
Thank you very much. I'm just about getting there. So thank you.
All right, thank you for getting us a copy of that. And so just for, before we close out staff presentation, would council like time to review this and ask more questions of staff, or do you want to save that? Can save it. Okay. All right, thank you, Eric. We'll go ahead and call the appellant. Is that Jim? Oh, it's Jim. So I believe we have the appellant's attorney online.
Right. Can you hear me? I don't see a hand raise feature here.
Yes, we can hear you. Thank you.
Okay,
Go
good.
ahead. Feel free to start your presentation. As a reminder, the appellant has 30 minutes for both initial statements and their rebuttal for all members of the appellant team.
Okay, and I won't take very much time on the initial presentation. Good evening, members of the council. My name is Jeff Kleinman, 1207 Southwest 6th Avenue, Portland, 97204, representing Mr. and Mrs. Claus. It's nice to be before you. Our fundamental argument under the first of the two appeal issues, which is the only one I'm going to address, is that time's up. That's the simplest way to say it. And time's been up for a long time on the applicant's ability to get, or the city's ability to approve, the requested modification in this case. If we look at the history here, there was a PUD approved in 1995, as staff explained, for Sherwood Village. That was the last time that the zoning would have allowed this mini warehouse proposal. In 2012, the initial subdivision approval, they were allowed to proceed with mini warehousing, not because the code allowed it, but only because of a provision that when you went forward on a PUD to subdivide, you could use the provisions previously in effect when the PUD was approved. Then in 2016, the site plan was approved for the mini warehouse development on this particular lot, and it was built out, and it's done. There is literally nothing to modify. Now the applicant has a different idea. That's fine. Apply for it under the current code. Nothing has survived the 2016 approval. And I would add that the actual city orders approving these applications did have time limits. They each had a 2-year limit. The subdivision had a 2-year time limit, and the site plan had a 2-year time limit, unless extended by the city. And the record does not show that there was any request or application for an extension. So they are gone. There's nothing to modify for the reasons that I mentioned. And the current code is what applies. This effort at bootstrapping just does not work. As to the 10-year limits that are established by the statute, I'm going to talk about those a little bit, but those would only apply if the city didn't set a different time limit. And then they would set a max of 10 years, regardless of what the city would have stated or had held in its regulations. But the city did determine a time, and it was 2 years on the subdivision and 2 years on the 2016 site plan. So in essence, as Mr. Claus's appeal states, the Planning Commission misconstrued the statute when it relied on ORS 92.040 to bootstrap this so-called modification into regulations that were only in effect in 1995, 27 years ago, not 10 years ago. I want to talk a little bit about the actual language of the statute. In my letter to you on the first page, I have set out subsections 2 and 3, and I primarily talked about subsection 3, but in listening to the staff presentation, I really want to talk a little bit about subsection 2, which says that only those local government laws implemented under an acknowledged comp plan that are in effect at the time of application shall govern subsequent construction on the property unless the applicant elects otherwise. In other words, for a shorter period or to go with the existing zoning. Well, at the time that the subdivision was applied for in 2012, the existing regulations, the existing comp plan would not have allowed mini warehousing. So what the applicant has tried to do and what the Planning Commission has done is to bootstrap 1995 regulations. That is not what's allowed by subsection 2. Subsection 2 is confined to plan provisions and regulations that are in effect at the time of application, 2012, not at the time of PUD approval in 1995, regardless of the city's code provision that said, well, when you apply for your subdivision in 2012, you can rely on the regulations from 1995. But that's not what the statute says. It simply says you're bound by the regulations or you can benefit from the regulations in effect at the time of the subdivision application. And when that was applied for in 2012, the regulations did not allow for mini warehousing. Then, as I explained in the letter under subsection 3, I think there's been a pretty dramatic misreading of the legislative intent and the language there. It says a local government may establish a time period during which decisions on land use applications under subsection 2 apply. However, in no event shall the time period exceed 10 years, whether or not a time period is established by the local government. So the statute establishes an outside limit of 10 years, no matter what. It does not say that if there are no local regulations, then everybody gets 10 years. If the legislature had wanted to say that, the legislature would have said that. Everybody gets 10 years unless there is a local regulation or a condition of approval which says a shorter period. So really, I think the applicant has been pushing its luck. I don't know what made them determine that they were unhappy with what was approved and built out in 2016, but it's too late to change it now. There is no way under the law that they can do that. The city did enact time limits in each of these relevant orders, and they were 2 years, not 10 years. So the time has long gone by for this application. And when you take into account the dramatic impacts of this number of storage units compared to the RV storage under the canopy, it really behooves the city council to give serious thought to what's proposed and what it's doing by allowing, by allowing a modification to which it's not entitled. Just taking a moment to review my notes. So we have also, in the letter I filed today, cited the actual language of the subdivision and the site plan approval establishing a 2-year time limit. As I said, there's nothing in the record that shows that those 2 years were extended. So I think that the case is pretty clear cut. To the extent that there is any ambiguity in the statute, I think it favors the reading that we are giving to it. That's the most plain and clear reading, because if the legislature intended more, if the legislature had intended a free ride or a golden ticket, so to speak, as the applicant basically contends, it could have and would have said so. Finally, in the last part of our letter, we were able to find one case that addresses the statute and favors the position that we have taken. If there had been in the subdivision approval a specific development or proposal that was approved for this lot, then there would be a right to rely on the statute's 10-year period, arguably. But that's not what happened here. And in fact, as I've said, and I'm sorry to repeat myself, the applicant went forward and developed. They did it already following the 2016 approval. So there is nothing left for this applicant to rely on here, and the application must be denied, the appeal must be sustained. On the issue of the rebuttal letter, which is the second issue on appeal, I'm happy to rely on what's already been stated in the appeal and on the record below. I think it speaks for itself. And lastly, I meant to do this at the beginning, and I'm sorry I didn't. Wanted to thank Eric for being responsive and very helpful in outlining the procedures for tonight and helping everybody get set up on Zoom. We appreciate it. So with that, I will be very happy to answer any questions that any of the counselors may have.
Sorry. So, thanks. By the way, I appreciate you bird dogging, trying to get that resolved. What I'm seeing here on my screen is Susan Claus is connecting to audio, but oh, she's there. Okay, great. Can you hear us, Susan?
Can you hear me is the question. Can you hear me?
Yes, I can hear you, Susan. Thank you.
Okay, great. At some point, what's the time left on our, there's no clock where I can see.
You have about 18 minutes left, Mr. Kleinman. And did I pronounce that correctly? I apologize.
You did.
Yes, just finished up, and I'm assuming that the appellant has more people that would like to discuss at this point or would like to present. Susan?
It's up to Jim and Jeff. I'm here for just a little tiny bit on the second issue, but I can do that at the end. I don't want to take a lot of time away from us. Thank you.
Hey, and Susan, this is Jeff. I've just opened, well, I've wrapped up my discussion and opened myself up to any questions from the members of the council.
Great. So Susan, did you want to present at this time, or I think you said you wanted to wait till later?
I think ask Jim. I think Jim wants to maybe do a little bit, but we want to reserve most of our time, right, Jeff?
Jim, would you like to present at this time?
Well, let me interject. I'm sorry, Susan. If you want to add something, you should do it at this point and just try to make it pretty brief. Don't save it for rebuttal.
Okay. Thank you. I'll just go very quickly on the second appeal issue. There was a lot of testifying that the staff did right now about what the Planning Commission thought at the time when we asked for the record to be open. They admit that the letter received by the applicant was only given a few hours before the hearing. The functional equivalent of it being entered into the record when they said that they put it on the website was still not given anybody notice. We did not see that letter in time, and we wanted to respond to it. And it's the statute says new evidence, arguments, or testimony. They're trying to make it so it's only new written evidence. And there was also arguments and testimony during the hearing, which we wanted to reply to. And that's why we asked for the record to be open for 7 days. And we still believe that that is was incorrectly not given to us. Thank you.
And Eric, are we down to about 10 minutes for rebuttal?
I'm sorry, Mr. Kleinman. Are you asking that we move forward now with
Well, I'm
the
just
applicant?
I'm sorry, I'm asking how much time we have left for rebuttal.
You have 15 minutes and 36 seconds.
Okay. Well, if the council excuse me, the council has questions for me, I'd be very happy to answer. I don't know if Mr. Claus has anything to add at this point. Otherwise,
Jim,
we
did you-
reserve for rebuttal.
Jim's going to come forward and speak for a moment. Yeah, yeah. And we'll add a couple minutes because of the having to deal with the technical issues.
Most of you are not, you have been in the city long enough to know what some of us are complaining about. And this is at the heart of it. Now, I've taught urban planning, and I have a PhD in urban planning and regional development from Berkeley, and I did a thesis that was accepted by the economists at Berkeley and Stanford in economics. So I always look at planning in a different way. I went to law school for 1 year and I had enough. So I went back, got a PhD. Now, a lawyer gives you the technical matters in the law. And you've heard a very good technical argument, whether you know it or not, that they've breached the agreement. These permits don't run on. They were 2-year agreements. They're over with. The lawyers explained that. He's given you briefs. I've given you briefs. But there's a bigger question. Do you realize we paid for Langer Parkway Road? That's my understanding. That's why the Community Arts Center is what it is, and that's why the cannery pollution was not cleaned up. We made a decision to take light industrial ground worth $5 a foot, put in the streets, put in the infrastructure, and Walmart, who was bought here by Joe Broadhurst, and we're looking at his and the Elks property and a small piece of ours. And my only condition was they had to come to a public hearing. I didn't want them here. I don't like Walmart. They're a category killer and they destroy your small business. Look at the downtown. They ruined it. And don't tell me anything. We rebuilt that hotel. We rebuilt most of the downtown and gave it back at cost because that was a central business district. It was fabulous. And that's what the urban renewal money was supposed to go to. That's what Hitchcock said. And then all of a sudden, Joe Broadhurst brought in Walmart, and Walmart went over to Langer's by Keith Bays. And if you don't believe me, call Charles Martinez or Kevin Sweet of Walmart. And more than that, we developed a large area with Opus, and Opus was told, go to the Langers or no place. Okay, that's fine. Now, this is an upper income community that's a village, and it has the only national wildlife refuge that's ever been started in the United States inside an urban area that is not hunting. And that was started in because of a lawsuit my wife and I fought, 8.5 years. And Mark Hatfield said that's the least we could do. That's how we got the refuge. So we started trying to build a village. And then along came Keith Bays. Your planners don't talk about the benefit costs of what we're getting by doing this. They talk about whether or not the Langers can shove it down your throat. And they can't shove it down your throat without Mays. Now, we're going to leave this town. I could say to Mays, so you'll feel much better. I have another operation on Thursday. They tell me I got a 50-50 chance of coming through. And that's one of many operations, one that made me deaf. So if I'm yelling at you, live with it. But you're not asking the right questions. What in heaven's name are we doing, building this kind of thing and overbuilding the density when we paid for the streets, we paid for the dirt, and the school children in Oregon gave up money? What is it giving us? And that's what you're here for. And that's what the planners are allegedly here for. They're not lawyers. And believe me, every time they've run hard into that, they've lost. And I don't see any analysis from your planners on the benefit cost analysis and the cost of traffic and whether or not there will be traffic out there that's going to cause trouble, and they're going to bring outside third-party traffic in. And so we can add more police on so we can defend Walmart better. Are you aware Walmart doesn't have a profile for this town? Either they can come close to fitting it. Most places wouldn't let them in without them bringing in their own police. We don't ask those questions because the Langers needed it. You know what you gave them? That ground was worth $5 a foot and they got 15 cash. That's $1 million an acre. And that's what happened on Home Depot. That's when the town started coming apart. Now Hitchcock left here before the swinging door caught him because he was speculating on a piece of ground that was a local improvement district in Sherwood. We had him and that's what bankrupted us. Everybody knew the boom was coming, so we went out, put in the local movement districts, and then we went bankrupt. We had people like Hitchcock come here, pick up that for the bond amount, eventually get 47,500 acre for it, and leave here a very wealthy man. And we're still having that hangover. People want to live in Sherwood, and you're supposed to protect their lifestyle, not bring in a totally alien lifestyle as to income profile and education and say it's a good thing and then scramble it into the code. You've got all kinds of indication. This interpretation, I hated this part of teaching urban planning because it's just an endless draw of trying to get the planner to see if you can't read it, go get an attorney. And Canada's worse. You do not in Canada under the British North American Act take discretionary powers and give them to planners because they fear it will corrupt them. And I know it does. Now you're hearing the same thing and you've already got your mind made up. You've made up it doesn't fit the profile. You've made up the jobs won't fit the profile. The housing isn't here. The traffic's going to go on. And no one is saying enough's enough. And that's where we are in the town. Now, do I care? Nah, I don't have that long to live. I'm lucky to be alive now, alive now. Well, that first operation, I passed away. You'd say, too bad you didn't stay there. But for a couple of weeks after that, I couldn't speak anything but Crow, and I couldn't hear. That's all right. Crow is a good language. You can watch somebody's lips and pick up a lot, but I don't understand what this is at all because you're wrecking the town. Look at what you've done out where a building we went out of the way to close down, the QT, tough guy. We went in there and closed him down. We didn't like what was going on. And that was a hot real estate, commercial retail spot. And what happened? You guys forced R1 housing back to an interstate. That's unheard of. And how's it happening? Because certain people are demanding the high $15 to $25 a square foot rent, and Mays goes along with it. You have a chance to stop it tonight. They built that out. Their code's there. You don't need to write it for Seth King, Perry Cogan, Cohen. Much as I dislike the law firm and their politics, I dislike any law firm that's politics, Republican or Democrat. The time's come for you to take a look at the benefit cost analysis to the city. And you're not. You're not. I've heard one single question about the profile of people using that, the origin destination of the transportation. You've already killed 5 people over that stupid Langer Parkway Road and that other idiot road that they made the wrong corner on. So now what you want to do is bring more traffic out here to hit more kids. You guys better get a grip on it. You've got a profile in this town and it's time you start fitting that profile with the buildings. And this, the first case, 1937, Amarillo versus the village of Euclid. They said you can do zoning less than a size of the best use, and you only need rational relationship. Then they came along with Necktown and they said, but you must have a variance. This is taking variance to reductio absurdum. It isn't even close. That's an illegal use. It's been out for 10 years. And we're sitting here and saying, let's build it again. And I'm going to tell you, you'll pass it because every single one of you are afraid of the Langers.
So Okay, I was just gonna remind you, I want to make sure you had enough time for rebuttal
What?
here. I just want to make sure, you're already getting up, but I wanted to make sure you had enough time left for rebuttal later on, so.
They don't need rebuttal. They already know they got the vote.
Hey,
So,
Eric,
just,
yeah, Eric, this is Jeff Kleinman. Sorry. How much time is left for rebuttal?
so right now we have 5 minutes and 22 seconds. I just wanted to ask Josh, because is it, or can we add 2 minutes because of the confusion we had with getting folks connected and those issues?
Yeah, I was watching the clock during that time. I think about 2 minutes transpired, just trying to figure out connections and who was going
Okay.
to speak.
So 7 minutes, 22 seconds, Mr.
Great.
Kleiman.
Thank you. And one other question. Part of my screen darkened out while I was speaking. Was I always audible? Was I always picked up by the recording?
Yes, you were loud and clear.
Okay, thank you. All right, thanks a lot.
That's a clarifying question. I think you read at the beginning, we're only allowed to use information that was provided to the planning commission, right? No new information can be used in our,
No new evidence. That's
no new
correct.
evidence.
Yes.
Okay.
Right. So to the extent there is any new evidence presented during that presentation, please don't consider that as part of your decision-making process.
How would we know? I mean, I guess, yeah.
Okay,
We didn't present evidence, or I didn't. I presented argument, not evidence.
Yes, I agree with that.
Got it. Thank you.
alrighty. Thank you, Mr. Kleiman. And I'm
You bet.
assuming you're ready to turn it over to the applicant.
I'm going to mute.
All right, thank you. I would like to welcome the applicant up to the chair and the table. I don't know if we have an official name for that, so welcome.
Thank you, Council President and members of the City Council. My name is Seth King. I'm a land use attorney at Perkins Coie, and our address is 1120 Northwest Cooch Street, 10th floor in Portland, 97209. And I'm here tonight on behalf of the applicant and the Langer family. And also with me tonight is Marie Holliday from AKS Engineering. She is here if there are any questions on the planning side that you have about the project. She'll be able to address those for you. The applicant concurs with the staff recommendation, and we believe that the appellant has not demonstrated that the city has committed any errors along the way here. So we request that the City Council deny the appeal and affirm the Planning Commission's decision. So I wanted to start out talking about a couple of pieces of context, which are in the record. First of all, we believe you should be confident in the process that the Planning Commission followed and in the decision that the Planning Commission reached. The Planning Commission held 2 different public hearings that were separated by 2 weeks. They carefully considered the application and all of the testimony. During that second public hearing, they took a 20-minute recess to allow time to review written testimony that had come in. After that time, they then reconvened and asked staff and the city attorney a number of questions. I think if you look at the minutes and videos of their meetings, you'll see that they really had a good grasp on the issues and the arguments on both sides, and were able to make a well-reasoned decision. The second piece of context I wanted to point out for you is that the interpretation that the Planning Commission made is consistent with past city practices. And this is referenced in your staff report that in 2016, the city relied upon the 10-year vesting provided by the 2012 subdivision and utilized that to approve development on the Langer's property. So there is precedent for the interpretation made by the Planning Commission that you're being asked to consider tonight as well. Then turning to responding to the particular appeal issues, and I'll just note I'm happy to answer any questions as I'm going through this if you do have any. So the first appeal issue, our response is that we believe that the Planning Commission correctly interpreted and applied the statute, which is ORS 92.040 in the present case. And just to recenter you on what that statute says, the relevant subsection is subsection 2. After September 9, 1995, when a local government makes a decision on a land use application for a subdivision inside an urban growth boundary, only those local government laws implemented under an acknowledged comprehensive plan that are in effect at the time of application shall govern subsequent construction on the property unless the applicant elects otherwise. So we take that and apply that to this case. In 2012, the city approved a subdivision for the Langers property, and that subdivision was it was a city decision for a subdivision. It's inside an urban growth boundary, so all of the triggers to this subdivision are in place, and as a result, then the local government laws that were in effect at the time of that 2012 decision would apply unless the applicant elects otherwise. Then regarding the time period for that, I know there's been some discussion about that, and I'll come back to that in a moment. We do believe that the 10-year time period does apply. But in terms of just the general vesting that occurred under this statute, wanted to respond to a couple of the arguments that you heard from the appellant on this. First of all, Mr. Claus had argued that the development agreement had undermined the vesting, and that development agreement between the Langers and the city had set out a shorter period of time when the 1995 regulations would be in effect. But as staff noted for you, there was nothing in the development agreement that appeared to contemplate any sort of future subdivision. There was no indication that if there was a future subdivision, that the applicant was waiving the vesting that would otherwise be available to them or anything like that. So we don't believe there's any reasonable basis to conclude that the development agreement undermines the statute and the vesting provided by the statute. I think in particular, one way to think about it, there isn't any rule that if you have vesting under one a provision of law that you can't also have vest separately under a separate provision of the law, and that's what's occurring here. And then regarding turning to Mr. Kleinman's testimony, one point he had suggested was that the 1995 uses were not allowed in 2012. So that even if the subdivision in 2012 vested the standards in effect at that time, that would not include the 1995 uses. And we believe that he's misconstruing the law on that. What the regulations in effect at that time said was that approved PUDs, I'm quoting this directly now, approved PUDs may elect to establish uses which are permitted or conditionally permitted under the base zone text applicable at the time of final approval of the PUD. So that provision was in effect and thus would have been vested at that same time. And thus that allowed the applicant to have that look back to 1995 standards in 2012. Then regarding the time period for the vesting, you heard Mr. Kleinman's argument on that, which at the end, he agreed that if the city had not set any other time period, that the 10-year time period would be what applied. So we believe that the city has not set any other time period, and thus that default 10-year time period does apply and is in effect right now. You heard Mr. Kleinman suggest that the 2012 tentative subdivision approval had a 2-year life to it, and that in his interpretation established a 2-year time period that the standards would be in effect. And we believe that that's not a persuasive position for primarily because we believe that would not be consistent with the intent of the statute. What the statute was saying was that once your subdivision is in place, in other words, not just that you have your tentative subdivision, but you have your final subdivision. Once that's recorded and in place, you have a particular period of time in which you can rely upon the standards that were in effect when you first applied. But that time period has to include a time when the final subdivision was in place. What Mr. Kleinman's referring to is a tentative subdivision decision in 2012. That has a 2-year life, but does not, but is implemented by a final subdivision decision that is then recorded. So in other words, it's that final decision that really is when an applicant could in fact develop their property. They wouldn't even really be able to develop it until the lots were created through that final subdivision. And then you also heard Mr. Kleinman suggest that the site plan that was approved had a 2-year time period. We believe that's irrelevant. ORS 92.040 only concerns subdivision approvals and not site plan approvals. So I think with that, I'm going to turn then to the second issue, unless you wanted to ask any questions regarding the first issue.
Questions, council?
So regarding the second issue, we believe that the Planning Commission did not err when it by not reopening the record to allow a response to a letter that I wrote dated May 10th, because that letter did not include any new evidence. And that letter is Exhibit D16. I'm sorry, I had misstated it as D18 earlier, but I believe you have that in front of you now. It is 4 pages long and does not include any new evidence. What you'll see in it is that I was responding directly to commentary made by Mr. and Mrs. Kloss earlier in the proceedings. The statements are all legal argument and reference to facts that are already in the record. I believe that, for example, I referenced a development agreement, but that was something that was already in the record. I referred in section B to testimony that Mrs. Kloss had made regarding entity documents that relate to the Langers, but that was not new. Those entity documents were not new into the record. In fact, the Klosses had submitted those earlier in the proceedings. So I was simply responding to why those entity documents were not relevant to the issue and didn't indicate that the Langers couldn't rely on the benefits of the development agreement anymore. So I think if you go through that, the only facts that are referenced are those that are already were already in the record at that time. But just to briefly summarize that statute again, the local government is only required under ORS 197-797 sub 6 sub B to reopen the record at a continued hearing if new evidence is submitted. And evidence is considered to be facts and information. It is not a legal argument where you'd be saying that facts should lead to a particular conclusion. Now, the definition of evidence does refer to quote documents, but that does not turn a written letter that is otherwise argument into evidence, because the point is not the form that it takes. The point is the substance of it. And the difference again between evidence and argument is that the evidence would be factual in nature, and the argument would be simply advocating for a particular conclusion. I think the only other point I would make on that is that there is a very similar case out there that was decided by the Land Use Board of Appeals, Talbot v. City of Happy Valley from 2016. And what that case said was that statements that were in a letter that said that state law limits the applicability of certain local standards did not constitute new evidence that warranted that required the city to provide a rebuttal opportunity. So I think that's just very much the same set of circumstances that you're facing here. And that, again, decision would say that the determination made by the Planning Commission was lawful, and that the city was not required to reopen the record here.
You remind, before you turn the page, would you mind repeating that case that you cited?
Sure. It is Talbot v. City of Happy Valley. It's from 2016.
Okay.
And I think the only other point that I would make during this initial presentation is that the testimony that Mr. Kloss offered to you tonight that concerned some various points, about Langer Farms Parkway, Walmart, Mayor Mays, the refuge, didn't think that any of that fell within the scope of this appeal hearing. So would say that's not information that you all could rely on in making your decision. So I think with that, we'll wrap up our initial presentation, and unless you have any questions.
Any questions from council? No.
Thank you.
Thank you, Mr. King. All right, so we will move on to, I believe we're at rebuttal with the appellant. Mr. Kleiman, is
Yeah, good evening again. Hi, you've got a pretty quick moving hearing, fortunately for you. So a few points, and really very briefly. First of all, past city practices or interpretations of a statute are not relevant and are certainly not controlling when a legal issue is raised under a statute, state statute, in a current case. So it doesn't matter how the city interpreted the statute in the past. It is neither binding nor helpful in this case. So I did not think that that argument was very well placed. It was also incorrect for Seth to state that I agreed that in the absence of a particular time limit in the city regulations or in a prior order of the city, that there was a gift of 10 years provided by the statute. It does not say that at all, and I thought I was pretty clear on that point. You do not get 10 years just because the city was silent on the issue at a particular point in time. And then on the issue of the effect of the 2016 site plan and the passage of 2 years since it was approved, I want to be really clear on that because I think it's a really important point. This is an application to modify the site plan. Reduced to its very simplest level and fundamental level, that's what this is. And there was a site plan that involved a storage facility, including storage under a canopy for RVs, and it's been used until recently when it was torn down. That approval expired 2 years ago. Now the applicant wants to do something else on the site, very much more intense and very much more traffic intensive. And they want to modify, what is it they want to modify? The 2016 site plan. It's too late. It is gone. You applied for a particular site plan. You did the development that was approved. And now it's 6 years later. So if you want to do something different from what you applied for in 2016 and what you built and what you benefited from, there's no appeal in that matter, as I understand it, then you file a fresh application under the current regulations. But there is quite literally nothing to modify. So by filing an application for a modification, I really think the applicant was trying to slip one by the city. And they're not entitled to do that. And the appeal is well grounded. The application should be denied. Thanks.
Thank you. Is there anyone else on behalf of your team that wants to make a rebuttal at this point?
Is there any time left?
We have 4 minutes and 36 seconds.
Okay, somebody tell Jim that. He doesn't know that. Let him know there's 4 minutes left.
Ouch. Jim's coming up to speak, Susan.
Thank you.
I've read both the legal analysis, and I'm not going to tell you what to do. But if you read them, some of which are on my pen, they can't do this.
So Jim, could you get a little closer to the mic? We've got some people that can't
Yeah,
hear you.
I can't hear him.
Oh, sorry.
Thank you.
I've read both of the arguments. I have reasonable respect for Luba.
I still can't hear him.
Okay, well, you're lucky. And there's no question, this is marginal on every corner. And it's where it gets marginal on every corner, you have to ask yourself a critical question. Are you going to allow an exception? Now, they try to say they're not, but they're whittling on their words. I love attorneys. I've got 4 boys that are attorneys, and I'm told all the time the worst disease in the world is a PhD in the liberal arts. Good luck to that one. But it's playing word games. You've got a decision to make here. What is the community getting out of this? And do you have any reason to give this kind of benefit to non-residents that have already picked up off of urban renewal between $30 and $50 million? You've already done that for this family. Now, don't tell me about the family, because my oldest boy went to school with Matt and Misty, and there was more than once over Larry Laws and Misty, he had tuffles at school because people wouldn't leave him alone. Incidentally, that's the reason he quit wrestling. One of the wrestlers hit a woman, and he said, that's it. I don't associate with those people. He's a good policeman. I wish he practiced. He was a great defense attorney, but he likes police work. But that's the boat you're in. There's no question you've got 2 very competent attorneys telling you this is done, and now you're asking, why would I go back and let someone redo a piece when they finished it and they walked away from it? And why would I give them a use that they went in and asked be made illegal? It's too much. And I would refuse it I tell my students, look at if you've got 2 equal arguments, and I will never say that their counsel equals our counsel, because our counsel is a better lawyer. That's the reason we hired him. But what I would ask you is, he's pointed out there's a flaw in every argument, and he's giving Luba cites. Let him take it up to Luba. And start making people work in this town to match the profile. But a great school system, we still do. I'd like to see it say that way. I won't be around that long, but that doesn't matter. I'd like to see interior pass. We're getting them. We fought with the county and we've got them. It's your job to protect us in a benefit cost sense, even from your own planners. Julia Hyduke is now the mayor of Staten. She's gone. Galati's gone. It's the citizens that have to protect the citizens. And that's what I tell you your task is. Now, Pete Wilson, when he was mayor of San Diego, when he was asked that question, called in a group of experts and came up with exactly opposite answers his lawyers and planners were giving him. And he got a sign code that went to the US Supreme Court and changed the law and protected speech. It's that kind of thinking that comes out of this council. protecting your citizens as you would want them to protect you. And I don't see why they need this. Good Lord. What the gifts we have given the Langers. We are the largest donor in this town. We gave in the flats to the Fish and Wildlife larger land than the Langer zone, and that was one of many pieces we gave away. And I'm very happy we did. This community gave us. And I think you had to look at how you can protect this community. Because your police do, everybody else does. Thank you.
Right. Thank you, Jim. Right, would the applicant like to?
Thank you. Again, for the record, Seth King for the applicant. And just a couple of quick points here. I'm sorry, could you remind me of my time? I don't think I'm. Okay, thank you. Give you a second. I don't think we're going to use all that. Oh, okay. Thank you. So regarding Mr. Kleinman's comments, I apologize that I misunderstood his argument regarding the time period. We'll say that I think our response is I don't see how you can reach any different conclusion under the statute. I agree with the city attorney that it is not the most artfully drafted subsection, but it does state that however, in no event shall the time period exceed 10 years, whether or not a time period is established by the local government. So I think right there, it's indicating that a 10-year time period is the maximum that would be provided. As we have stated, we don't see that the city has taken any action to establish a time period less than that, either by ordinance or something specific to this case. So we believe that it's that 10-year time period that applies under the statute. As to Mr. Kleinman's site plan argument, as I understand it, he is saying that the 2016 site plan is gone. That I think I'm quoting him directly there. He said it's too late but I think he may be misunderstanding. We're not modifying the application. We are, in fact, submitting a new application, which is called a modification. It's a specific type of application that the city has, which says that if you have an existing approval out there, you can come back and seek a modification of it. And that is what we have done here. We have addressed the criteria for that modification and gone through the appropriate process for it to be reviewed and so forth. So I think it's not relevant that the 2-year implementing period for the site plan has passed, and when in fact the site plan was implemented during that time. It's that now there is a brand new application that is seeking to modify it. And another point I wanted to hit, this is relating to some comments you heard earlier about a LUBA decision relating to ORS 92.040, and it was the Group B decision from the city of Corvallis. And we, not surprisingly, read that decision very differently than the appellants do. We believe that what LUBA said there, properly construed, is that even if a local government is not approving specific development at the time that the subdivision is approved, if the local government is still approving lot size and configuration that is premised upon a particular type or location of future development, then the local government is precluded under ORS 92.040 sub 2 from applying different or conflicting standards to that development in the future, at least during the vesting period. So I think what was going on in the Group B case is that there was, I think maybe like an L-shaped lot, and although they didn't propose any development at that time in the long portion of the L, LUBA determined that, well, that particular lot configuration must have been premised on there being some type of development within that long shape of the lot. So the city couldn't come back later on and say that standards that would prohibit development in that location would the city was precluded from applying those to prohibit development in that location down the road. So I think that is all that I had. So I think with that, we would just circle back to where we were in the beginning, which is that we believe that the appellants haven't demonstrated that the planning commission committed any error. And so the appropriate outcome here is for the city council to affirm that decision. Happy to answer any questions that you might have. Thank you for your attention.
Great, thank you. Any questions for the applicant? Sean, do you have any questions?
Not at this time. Nope.
Okay, great, thank you very much. So Josh, refresh my memory. We're now.
Next step is final comments by staff. Eric, did you have any additional comments you want to make at this point?
Thank you,
Thank you,
Council
Eric.
President Rosener. Be very brief. Eric Rutledge, Associate Planner with the city. Just a few comments in response to everything you've heard this evening. I would agree, just want to state that, if you heard anything this evening that has not already been included as part of the record, I think there was quite a bit of that. Just a reminder, you can't take any of that into your decision making this evening. It's strictly based on the record and the issues on the appeal. So please keep that in mind. Number two, we heard about, well, actually, I'll skip that. Second is that the major modification process is the correct process. So Seth is correct that even though there was a site plan approval in 2016, there is a clear process in the code for. Jim, are you okay? I think we're okay. There's a clear process in the code to modify a previously approved site plan. So that's what they've done. And then I think really the big question, it seems like, is whether or not this ORS, allows automatically a 10-year period or not. And so I just want to circle back to Josh and get your opinion one more time on that one and this sort of staff's opinion on that. I think we can leave it there.
Yes, thank you. I agree. I think that does seem to be kind of the key issue that we're focusing on here is whether that default is a 10-year period. And as you've heard a couple times now, that section of the statute is not a model of clarity in its drafting, but I don't think that you can read the statute any other way without defeating the purpose of the statute. There has to be some sort of time period. It's either forever, or it's 10 years, or it's rendered ineffective, right? And the statute clearly says it's a maximum of 10 years. If it's not an automatic 10 years, what time period is it? The rest of the statute would be rendered meaningless if the 10-year period did not apply. Happy to answer any questions about that, though.
I have a question as well on something else.
Eric, so one of the things as we were hearing testimony that I was kind of wrestling with, I think I heard answer, but I would like you to answer it as well. So the idea that this is a major modification and not a new application, I think was something I was struggling with. And it sounds like maybe that's just a terminology issue. This is a modification not to the original site plan approval, but a modification to the site itself. Am I thinking about that accurately?
Yeah, if I understand the question, so there's a 2016 site plan approval. There was no development on the site before then, no physical improvement. So they got site plan approval in 2016, constructed everything that's there now. And now we're in 2022 and they are applying for, it is technically a new application. And we have a very clear process in the code for an applicant or a property owner to modify a previously approved site plan. And so it's very clear. It says, here's the process. You follow the same procedures as the original. That's why it's a type 4. That's why I went to planning commission. And it says, here's the approval criteria. Basically, the way it works is anything that the applicant is touching on the site has to come into compliance with the current code. So this modification included a transport. We've heard traffic issues about traffic this evening on this application. They did provide a trip generation report that indicated how many trips would result from this specific modification. We're taking away a canopy, adding 575 storage units. Here's how many trips. Here's why no traffic mitigation is needed. So there's a clear process to do a modification in our code, and the applicant followed that process.
So why are some new standards applicable in a modification like the traffic thing, but not others? Why, like the fact that this isn't an allowed use on the site anymore?
I think they come down to the language of unless the applicant elects otherwise. So the sort of the splitting of the code, if you will, is.
I assume the applicant didn't elect to do a traffic standard and pay additional SDCs.
Yeah. Any help on that one, Josh?
Yeah, I think,
You get my question though, like,
yes,
okay.
yes, I
Right,
think
right.
the new standards that were applied, correct me if I'm wrong, the new standards that were applied were only more burdensome on the applicant than they would have been otherwise. So the applicant went through additional hoops as a result of the new standards that they wouldn't have had to under the old code. So they could have objected to that and said, we only have to do what was required by the 2012 code. They did not. And so they did more work than would have been required under the 2012 code.
So what you said you had very clear processes or protocols or something, like for how long can you modify a site plan? Like when does that become no longer an option and you actually have to do a new site plan? Like it just feels like it's a really weird, quirky part of the code. I'm trying to understand. Like why is there distinction between, oh, you're allowed to modify a site plan that was 5, 6, 8, 10, 20 years ago? I don't know. What's the expiration on that?
And I think you're right. It's just kind of a nomenclature issue, what we call it. Once you have approved a site plan and you want to do something different, we call it a site plan modification. We could recall it a new site plan, but we call it a site plan modification because there was already a site plan.
Right. But only
Forever, basically.
Right, forever. But you're only allowed to use the 10-year vesting of allowed uses for 10 years. You could do a new site, you could do a site plan modification from a site plan that was approved 15 years ago. And in that scenario, you wouldn't get the benefit of any vesting because that's different language that.
Right. And I think
so it's just a weird, quirky part of our internal code that we call these things modifications, which seems confusing.
Yeah, and I think the key is that, whether we called it a major modification or a site plan review, let's just say we called it a site plan review every time, whatever we called it, the key is that when they come in, we take a look at what they're modifying and take it under the current code. So we are bringing it up to whatever's modified, we bring it up to current standards. So even though.
Unless they want to use the 10-year-old standards.
If there was a subdivision, yes.
I think the other thing, taking a step back and viewing this from a higher level, this question of site plan modification and whether the site plan is expired, that was not raised at the planning commission and was not one of the issues on the appeal.
Okay.
So it's really not, I don't think it's really relevant to this discussion. And I don't think I think the argument, if I understood correctly, was that somehow because it's a site plan modification, that has some bearing on the vesting question. And the statute doesn't say it only applies to a modification. It says any subsequent construction of the property, regardless of what you call it. If they submitted a new site plan application, we would still be looking at ORS 92040 to determine whether what standards would apply.
Thank you.
I think mine's answered.
I don't have any of Eric. I don't think. Oh wait, hold on. Oh, Hold on, Eric. Got a couple more to ask. Kim?
Well, and this may be to Josh, I'm not sure, but that ORS 197, the one where it talks about the evidence. Blah, blah. I thought Mrs. Claus referenced it saying something about evidence and arguments. But can we just
I can respond to that.
clarify that exact ORS?
In a
one?
different part of the statute, it talks about all those, but in the section that's relevant here where it's asked, it's talking about when you would have to leave the record open for rebuttal. It's only in response to.
And I
written
think you
evidence.
had that in your presentation, but can you just?
And I can just read, it says, an opportunity shall be provided at the continued hearing for persons to present and rebut new evidence, arguments, or testimony. So that's one sentence.
At the
So
hearing.
at the hearing. So we opened the hearing and allowed the appellants, Jim and Susan, to provide testimony. And that satisfied that first part. So they were able to provide oral testimony at that hearing. And then the second sentence is, if new written evidence is submitted at the continued hearing, any person may request that the record be left open for at least 7 days. So they're separate. It's, you get a chance to provide testimony at the continued hearing. And then it's, if someone does actually show up and provide written evidence at the hearing, then, and then if someone also requests to respond to that, then the commission should leave the record open.
Read the first.
Yeah.
Question.
So,
sentence one more
and
time.
we can pull it if we need to. An opportunity shall be provided at the continued hearing for persons to present and rebut new evidence, arguments, or testimony.
Somebody could have presented new evidence, but nobody did.
That's what the commission found.
That's what the commission found. Okay.
And,
But yeah,
I'm
someone
sorry,
could.
on-
Someone
On
could,
that
yeah.
part, you said that they could be able to respond to arguments, so didn't you?
I may have misspoke. It'd be respond to the new written evidence submitted at the continued hearing, and then they would request to respond to that written evidence submitted at the continued hearing.
Okay. And we've heard from a couple of lawyers, including our own, for the city, that this is an argument and not evidence. Am I saying that correctly?
That's
Exhibit
how
D16.
I
Exhibit
view
D,
it,
yeah,
and
this,
question
the
is if
letter
you
D
agree.
16.
I read it and I considered it an argument.
Same as me.
Yeah, I did as well. I'm not a lawyer. I'm an engineer.
Sean, did you have any questions?
I don't. I think Eric and Josh have done a good job of providing some summary information here. So I'm satisfied.
Sean, was that your cat?
Or Lily.
That is the cat. Lily is getting herself ready for bed right now.
Awesome. Thanks, Sean. All right, so are we on to deliberation at this point?
Yeah, if there are no further questions, I don't recall you officially saying that you closed the hearing. So let's do that. And
If
then
we don't, yeah, so I guess I'll officially close the hearing at this point, and we'll move on to deliberation amongst council. And Josh, or just for everyone listening and everyone in the room, our options at this point. Let's deliberate and vote.
yes, that's
Okay.
correct.
All right.
And we can pull up again if it would be helpful, the three options.
I have them right here.
Eric, do you want to pull up that slide from your presentation, but there are three options?
Shift F5. Shift F5.
Gotcha.
All right, thank you, Eric. So we're on to deliberation. Is there any comments or discussion in the council would like to make at this point?
I mean, I have one. I've lived here for, I don't know, 18 years or so, nowhere near as long as as some people here, but I don't know that I've ever met a Langer in my dealings. They could be great people, they could be not. I feel like bringing which family is applying for this is probably not as relevant as looking at the application and the did they meet you know, criteria of the application, stuff like that. So I'm personally trying to discard, I mean, frankly, yeah, I have all sorts of feelings about all sorts of vendors and people in communities and stuff like that. And I have to check those at the door to say, hey, is this, you know, clear and objective and fair for the people that are applying for it. So just know in my comments and my thinking of it, I'm trying to, you know, separate it from, you know, are these people good people, right? I guess.
Yeah, well, no, no, I agree with you. Our role here is to evaluate this based on the evidence presented to the
Yes.
planning commission and the applicable ORS and Sherwood code.
100%. Yeah. And so I just want to be super clear that I'm not trying to make a judgment one way or the other as to whether, you know, yeah, it's only, is this appropriate to the code? So,
Yeah, state
anyway,
law is very
state laws,
specific about
exactly.
that.
Yeah,
what our
exactly.
policy is.
I just wanted to be really clear.
So,
Go ahead. Go ahead.
I don't have anything. To
this was an interesting hearing for me because at various points throughout the hearing, I was listening to testimony come in and I felt like, oh, I'm seeing problems with the 10-year thing. I'm thinking about like this point, this is a problem for me. And this seems like something I would, you know, overturn on. And then as we went through the whole hearing and we heard all the testimony, I was convinced that, nope, that's not a thing and the same thing with the modification language, which I was hung up on. So, I feel like I've been very open-minded and like I said, there was various points throughout the hearing where I was in my mind thinking, well, I think I'm going to probably overturn, or vote to overturn. But then all of those questions were answered and answered very clearly to me. And so I feel like the planning commission did their job appropriately. They applied the code appropriately with help of legal counsel. And I would suggest that we affirm the planning commission decision based on the evidence tonight.
Thank you. Sean?
Yeah, I would agree with that. I think we heard a lot tonight. I heard some of it relevant, some of it not relevant to the actual laws and the statutes that we're looking at tonight, and the decision that was made by the planning commission and how they made that decision based on their interpretation of the code as written. And I think it's been spoken today that there are clearly some inadequacies in the way that it's written right now. But I think, that's something for another day. I think what we need to do is we need to look at the way it's written as it was decided at the planning commission and judge on that. And I think from what I've heard tonight is I'm going to let I'm willing to let their ruling stand or their decision stand.
John Kim, do you have anything?
No, I was just gonna say the same thing. I've listened to all the evidence and all the testimony. And, we have planners. And he just admits he's not an attorney, but we do have attorneys who have looked at this, who are giving us guidance as well, thankfully. So, I will ready to make a motion.
Well, before we jump to that.
Yeah.
Did you have something else you want to say?
Well, I was going to just, I didn't state my position before. And so I was just saying that I was going to ignore the personal connection, on this, but I've got to also say as somebody who, I feel along with Kim, the planning commission were extremely deliberate in this and trying to be as careful as they could to check with lawyers and to make sure that the reading and the understanding and we're done in accordance with something that obviously we're hearing from our own lawyer that it's not as clear as we would like it to be, but it was an accurate reading that was able to be, that is defensible and is, you know, able to be defended, I guess. But I am a big proponent of supporting the volunteers there, as well as who are really knowledgeable on this kind of stuff. And so I also would be in favor of confirming their decision, just based off of what I've heard here has not been enough to move me off the fact that a mistake was made, or that something was done inappropriately, or because of bias, or because of anything. I haven't heard anything to that would say, oh yeah, there's a red flag here and we have to stop and adjust this because of something that was nefarious or underhanded or illegal or anything like that. And so that would be my vote. Or I'm leaning, I guess. I'm not
Okay.
voting yet, but
Your recommendation.
my recommendation.
Thanks, Taylor. So, you know, first of all, I wanted to thank Mr. Kleiman, Mr. King, Jim, thank you very much for coming in tonight, and Susan coming in via Zoom to present tonight. I think, you know, I came into this, I mean, we have an amazing planning commission with a lot of people that put in a lot of time. We have some people on there that have been on there for, gosh, years and years and years, and have a lot of, excuse me, experience, and they're backed up by staff, our city attorney, who does an amazing job, and all the resources that you have behind you to look at this stuff. So when I look at these things, you know, all that being said, we do make mistakes occasionally, you know, so we have to take it seriously. You know, that's kind of how I approach this. You know, did we make a mistake? And do we need to rectify that mistake? I, like Doug, was kind of going back and forth a little bit, you know, as I was hearing different things, but I kind of where I've landed. My recommendation is we affirm the planning commission's decision, because I don't see anything here that would warrant us overriding that decision at this point. So that's where I'm at. So,
All right.
so does someone,
I would like to make a motion.
before we make that motion, do we need to have a motion before that to change the signer?
Is that-
I was just going to do it in my
You're
motion.
gonna add the motion. Okay, great, thanks.
I move that the city council tentatively affirms the planning commission decision and approve the application based on the planning commission findings report dated May 11th, 2022. I further move that the city council should authorize the council president to sign a notice of decision, including written findings consistent with the council's tentative decision on or before August 4th, 2022.
Second?
Thank you, Doug. Thank you, Kim. Any discussion on the motion? All right. And Sylvia, do we need to do a roll call for this? Or we just? No, okay. All right, so we have a motion and a second. All in favor?
Aye.
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 All opposed? Motion pass. Thank you, everybody. And thank you, everyone for coming to the hearing tonight. Thank you, Eric, and everybody else. All right, with that, we will move along in our agenda, and we are off to city manager report. Keith Campbell, are you on?
Yeah, I am. Thank you, Council President. I just wanted to say my wife and I got to experience our very first Robinhood Festival this weekend. Friday and Saturday were just outstanding. We had so much fun, and just really enjoyed the energy and the community. It was just a really amazing and special event. And I also wanted to do a special shout out to Harry Bannister and the Public Works crew, who was part of the behind the scenes, the people that help work with those organizations, from Cruisin' to Robinhood, to really make that go. And I know a couple of times I reached out to Harry, and he just was responsive and helpful. And I've heard, you know, I've heard comments from people and individuals working with those groups, and just wanted to give a special shout out and a thank you to them for their work as well. And so I don't know if Craig's there or not, if he wanted to add anything, but just wanted to give a special shout out to them.
Craig just gave a thumbs up from me.
All right, I'll take it. Also, I just want to recognize tonight is Josh Soper's last meeting with the city council, and I just wanted to wish him well and thank him for his service to our community, and best wishes on his next endeavor. And with that, I'll be happy to answer any questions.
Any questions? I was just, well, it's probably not for the city. I was gonna wonder what the attendance was like at Robinhood Festival, if there's any numbers on that. And
Big, huge.
yeah, it seemed like there was a lot of people. I just didn't know if the city had any official.
I have not heard any official numbers yet.
Okay, all right, thanks.
All right, I guess we'll move on to council announcements. Who would like to go
I'll
first?
go first. Not really an announcement, but there was no Parks Board meeting this month, so I assume we'll meet again in August, and I'll look forward to that. But I did want to say how great it was to have the Robinhood Festival back after 3 long years, and it was great to get out there, and thanking Sylvia and everyone who was a part of putting together our float that we rode on, and I had a lot of fun with that. And also just great to see all the festivities and the community out and about, and the weather was, in my mind, perfect because the sun wasn't beating down on me in the parade. So I just really appreciate the community. Also, Music in the Park continues tomorrow. Cloverdale will be playing Music in the Park, so show up for that as well. And thanks, everyone.
Sir? Kim?
I'll go. Yeah, I mean, we're all probably gonna say the same thing. I was just so pleased with Robinhood and the smiles on people's faces, and it was crowded walking through there, and Saturday night hit machines was just jam packed. Hardly could get out of the beer garden area. So that was really great. But I just want to echo what Keith Campbell said, and Josh, I've worked 5 years with you now, and almost 6, I think now, almost 6. So you had just been a great asset to us as a city, and you're going to be truly missed. I just want to thank you for all the time that you've taken to answer my questions, to educate me and on legal issues that don't make sense to me sometimes. And then you're so calming, and you take the time and make it user friendly, how you explain things. I will miss your writing. The way you write is, I think I remember a counselor who was a friend of mine who was on council when you were hired, and she said, one of the things she said was the thing they noticed most through your application was how well you wrote. And I could just, that will be missed. So wish you well at BEH, and thanks for all your service.
Thank you.
Set a high bar for the next person.
Yes. All right, and Josh, I just barely met you, but thank you for getting me up to speed, and I appreciate your service to our city as well. We have met with the Planning Commission this last week, had another long meeting. We'll be seeing some of that. I did notice that construction has started on the Oregon Street Tech Park there on the way out of town. You can see the land is being cleared there, so it's great to see some of that land being used. And again, at the long meeting with the Planning Commission, I've got to, I'm showing my bias a little bit, but thank you to all of those. We've got some long timers and some new people that are volunteering on that, and our city planners. So thank you for your time and effort, and frankly, everybody that serves on our commissions. The city really can't function without you. So thank you for that. I feel like, I'm drinking from the fire hose a little bit as I'm getting up to speed as a city councilor, and I'm more and more impressed at the citizens that step up to help the city that we all love run better. And it really it is really heartening to me as a citizen, and now as a counselor, to see all of that work and effort being put in. So thank you to the volunteers as well as the city staff. I'm continually impressed at the level of quality that they give us. That's it for me. Sean.
Yeah, I'll just mention a couple things. I will also echo a lot of the good sentiments that we have for Josh. Josh, sorry, I'm not there in person, as kind of alluded to earlier. I am on childcare duties this night, and I'll explain why in a moment. But yeah, Josh, it's been great working with you over these past few years. I can say unequivocally that you are my favorite lawyer. So thank you for everything that you have done for us over the years. To echo what Kim says, your skills in writing and explaining complicated legal issues in a way that state the facts and yet make sense has been invaluable to us over the years in guiding many of my decisions. And I know that your love of the city of Sherwood and you know, the work that you've done to help us throughout the years has been just amazing. So I'm really excited for you and happy for you for your future. Of course, you'll be missed here. And as was said earlier, a high bar has definitely been set. But you know, best of luck to you in your future endeavors and with everything else. As I kind of alluded to earlier, the reason I am home with a cat and a small child is my wife and two oldest daughters are participating in the SFA's production of Cinderella, which is opening this weekend and also is next weekend. So Friday night, Saturday night, and a Sunday matinee, both coming weekends. So I think tickets are still available. It's going to be at the Center for the Arts downtown there. So if you're interested in seeing some theater, again, kind of another thing that's coming back slowly through this, through some recent cancellations in previous years due to the pandemic. So, and it's the Rodgers and Hammerstein version. I don't know if I mentioned that versus the Disney one. So there's some variations, but it's still going to be a treat. The one other thing I do want to call out, and Taylor kind of referred to this as well, as our great city volunteers. On our consent agenda this evening, we did mention that Casey Chen was re-upped as a part of the Cultural Arts Committee, and I did want to just call her out specifically as I am a liaison to that committee. Many of the great works that we've done here and the events that have happened recently at our Center for the Arts, and one that pops to mind immediately was the Lantern Festival that we had in celebrating the Lunar New Year this year. Casey was really pivotal and just went above and beyond to help with that event, helping out in a lot of our chalk art things. Casey's just been very valuable in her time on the Cultural Arts Committee. So I'm glad to have her back and extend that also to everybody else, to our other committee members. And I know that we do have some vacancies available on a few of our boards. So if anybody is interested in joining, please do check out the city website. There's some information on how you may volunteer to join us here. So that's all I've got. Apologies for rambling. I know it's late, so thank you.
Thank you, Sean.
Hey, Tim, if you don't mind, I'll let you close. And I'll quickly step in. Big shout out to the Robinhood Festival Association, all the volunteers, all the sponsors for a fantastic weekend, wonderful festival enjoyed by everybody. Shout out to city staff and all different departments that lend a hand to help it be successful, including but not limited to Public Works, police, and some admin folks. Josh, we've talked before. I think we've even talked in a prior meeting. Wish you all the best. You convinced me the value of having an in-house attorney after my initial skepticism. You won me over, and we were better because you were with us, and brought a great skill set that you're now going to leverage to go private, which I'm very happy with you. If you're going to go to a private firm, BEH is one of the best, if not the best, in Oregon, and we know you're going to continue to thrive and excel. Your accessibility to city staff, to city councilors, to help address issues as they popped up or that you needed to make us aware of, was fantastic. And while you won't be with the city. We know where you're at. If and when we need some help. Yeah, we know that we'll get great advice and assistance if and when we need it from BEH. So great job. Thank you very much. That's it.
So, excuse me. I'm going to start with you, Josh, because the rest of my stuff's boring. So he was elevated for a second, but you know, I just second everything everyone said here. I think you've done a great job. The city, you've left us in a better place than we got here, which is always the hallmark of a great employee. Sad to see you go. Last chance. You don't have to go. Speak now. But no, really appreciate everything you've done. I've worked with many attorneys in my career, and most attorneys are very A-type, and I've got a position, and you've always done a good job of laying out the facts and telling us what our options are. And I've always appreciated it. So thank you very much for your service to the city and to the council, to staff. I wish I could have been at the Sherwood Robinhood Festival. I was at space camp with 40 kids from the city of West. Got in really late that night, so we had a great time. Haven't heard of Space Cats Camp? I encourage you to look it up. It's an amazing experience for kids, but that's where I was during Robinhood Festival. But everything heard great. So good. Great, your department did a great job. Success. So thank you very much. The real quick boring things. Next week I'm headed to Atlanta for the National League of Cities Conference. And, we'll be firming up our agenda, our policy agenda for lobbying, the FTC, NATIO, our congressional delegation, other congressional leaders out there on all things broadband. It's a great opportunity for us as a city as we push forward on broadband. So always looking for more money from Washington, D.C. to help us with our projects. And, not just money, but also looking for a regulatory environment that makes it easy for us to get broadband deployed and service everybody. Anyways, I'm sorry. And then along those same lines, the internet technology communications MLC meeting today, which is great. So, but I'm just going to leave that. Anything else for the good of the order? John, Heath? I will officially adjourn our meeting. Thanks, everyone.
Thanks, everyone. Have a good night.
Good job, Tim. Cheers.